Sakshi TV's special immigration talk show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy LLC. Prashanthi Reddy garu, welcome to our show.
Thank you, Shivani.
Yes. Ms. Prashanthi Reddy, we thought we'll discuss a little about the top 10 tips that are required for the filing of the H-1B cap. So without any further delay, can we get onto the topic, or do you want to cover any latest immigration updates that we have received this week?
We should be able to start. One moment.
Okay.
Having some issues with my document.
Yes.
Okay, let's start with the top 10 filing tips for H-1B cap. We all know that H-1B registration just got over, and we're starting to now file H-1B cap petitions. H-1B cap petitions, we can start filing them as of April 1st, and we have until June 30th to file them. So that much information I think most of us have. So I thought it would be apt in this show to discuss those, the filing tips for H-1B cap season, whether you are a beneficiary or you are an employer, and you're an employer and you're doing it yourself, or you're an employer and you're using an attorney. Either way, it's good information to have. So let's start off with tip number 1. So tip number 1 is the registration selection notice has to be submitted. Without that, your entire petition will come back. What is the registration selection notice? Once you file a H-1B registration, USCIS conducts a lottery, and if your case gets picked, then they will send you a registration selection notice that your petition has been selected, and there'll be a confirmation number on the registration selection notice. You have to make sure you enter that number into your I-129 petition in the H supplement under question 5. Make sure you review all the information carefully provided on the registration notice. The registration notice also has an address that they want you to send the petition to, so make sure you send it to that address. Don't go to the USCIS website and look for the address on the website like we usually do. They want us to send it to the address that's on the registration notice. The reason they do this is they're trying to distribute the H-1B petitions equally among all service centers, so there's no delay if one service center receives too many applications. So again, review what's on the registration notice. Make sure that information on your registration selection notice matches the information in the H-1B petition. So whatever information that you're putting in the H-1B petition has to match. And if it for some reason doesn't match, then USCIS could potentially deny that H-1B petition. So it's important that if you see that there were any mistakes made, or say some information has to be updated, you should notify USCIS in a separate cover letter of that changed information. An example of this is if the beneficiary has a new passport and the registration was entered with a different passport number. So make sure you submit the new passport and you submit the old passport. You submit information showing that both passports belong to the same person, and put it in a colored paper on the top of the petition so that there are no chances of a denial. Also, sometimes companies move after they file the registration, they move to a different location. Same thing, put a copy of the lease. They again want to see that the petitioner that submitted the registration is same as the petitioner that's now filing the H-1B petition. So you have to again explain clearly that the information is different, but the petitioner is the same. Tip number 2: make sure you include the proper forms in your petition. Otherwise, again, the case comes back, and we have no control over when the case will come back. Sometimes it takes a month, sometimes more than that. So it's possible that the petition might come back after your 90 days filing period. So you want to make sure you do it right the first time. So submit your H-1B I-129 petition, the H supplement petition, the H-1B data collection form, And, if you're exempt from the filing fee, then, a filing fee exempt supplement. But you have to make sure you check the edition of the form that you're doing. So make sure that it's a current edition. The latest edition for the form will be dated November 2nd, 2022. That's when the last update on the forms occurred. So make sure you're using the correct version of the form. And that version again is November 2nd, 2022. If you don't use the right version, guess what happens? The petition comes back. Tip number 3, make sure your checks, the filing fee checks, are dated, signed, and in the correct amounts. Also, USCIS wants separate checks. There are several checks that have to be submitted, several types of fees that have to be submitted to the USCIS when we're filing a H1. We have the basic fee of $460. We have the fraud fee of $500. Then we have the fraud detection fee of $750 or $1,500, depending on the size of the employer. It's $1,500 if it's over 25 employees, and $750 if it's under 25 employees. So make sure you put in the correct check amount. The most common reason for H-1B rejections is an incorrect check amount, or check being written wrong, or not signed, or not dated. So the checks have to be dated within the past 6 months. Sometimes checks are valid for even less than 6 months. Sometimes it's written on the check that valid only for 3 months. If that's the case, then you shouldn't be using a check that is 3 months old or more. So make sure the validity of the check is current, never more than 6 months. Tip number 4, confirm the correct filing location. USCIS will designate again the service center where the petition should be filed. That is usually written on the registration notice. So again, make sure you file it at that office. And usually they will give you a different address if you're filing by courier service, and it's a different address which could possibly a PO box if you're filing it by regular mail. So make sure you use the correct address, because if you're filing by FedEx or UPS, you cannot send it to a PO box because FedEx will not deliver. Tip number 5, signatures on all the forms. Make sure that all the forms are signed in the appropriate places. The I-129 has to be signed in one place. The head supplement has to be signed in 2 places. So, G28 has to be signed. So all the forms have to be signed. Make sure that you're signing all of them and dating them. USCIS announced on July 25th of last year that they will accept photocopies of checks. Photocopies of checks were always accepted for LCAs, but for the H-1Bs, they wanted original signatures. But due to COVID, they allowed us to submit photocopies of checks. And I guess they figured that, that system made sense and was extremely efficient when compared to the older system of expecting original signatures. So they've made that permanent. So now they're agreed to permanently allow wet signatures or photocopies of signatures. So when they say wet signatures or photocopies of the original signature, that means that the employer can sign and then make a copy and then send that to USCIS. Especially if you're sending it to your attorney, then you can send that to your attorney and your attorney can send it to USCIS. Remember that USCIS will not accept electronic signatures. There's a difference between a wet signature and an electronic signature. They do not accept electronically generated signature. You have to actually sign your signature and make a photocopy of it. So that's something that to keep in mind, because then again, the case will get rejected if they see that it's an electronic signature. And it's very easy to make out the difference between an actual signature and an electronic signature. Tip number 6, the start date listed on the form I-129 has to be October 1, 2023 or later. So you have to remember that that depends on when you file. But it always has to be October 1 or after October 1. Now, if you file on April 1st, then it has to be October 1st, because you can never file a petition more than 6 months in advance. So always make sure that, obviously, since you can only start filing from April 1, the signature will have to be October 1st or later. So if you're filing on April 5th, you can have a start date on the I-129 petition on October 5th. But I suggest, and we always just put in October 1st by default. The only instance in which you would not put October 1st is if USCIS goes through a second lottery in July or in November, and you file the case after October 1st, then it doesn't make sense, obviously, to put in October 1st as the start date, because that date has already passed. So when a new lottery is done, they again give you 90 days to file. So say if the lottery is done in July, then they give you until October to file. So they give you 90 days. So obviously, if October 1 has already passed, then you will put a date after October 1, but always make sure it's after 6 months. It's not more than 6 months, rather. Sorry, it's before 6 months. Tip number 7. Ensure that all the boxes are check marked or completed. So any unchecked or unanswered section, again, could result in a rejection of the petition. It depends on how important that particular question is. If it's a really important question, then it could simply get rejected, or there could be an RFE, depending on the type of question. If you think that question is not applicable to you, please put in NA. Try not to leave anything blank. Not applicable, put NA. Otherwise, fill it out with whatever information is being requested. Make sure all the tick marks are there. Information such as, is it a transfer? Is it an extension? Is it a counselor processing? If you don't mark the first page of the I-129, then your petition will most probably come back and not even get RFE'd. They'll send the entire petition back. If it's not signed, the same thing can happen. So some columns are really important to mark, and if you don't mark them, it could just get rejected by the mail room. So they send everything back along with the checks. Tip number 8. Check the LCA job details. Double check, triple check that the certified LCA corresponds to your H-1B petition. For example, the job title. Look at the job title. Make sure you're using the same job title in your I-129 petition. The work site location, make sure it's the same. So the wage rate, so the offered wage as well as the prevailing wage. And also you have to make sure that, of course, that the LCA is approved before you file your H-1B petition. You cannot use an initiated LCA or a pending LCA to actually file the H-1B petition. It has to be an approved LCA. Also, with reference to, again, this goes back to cross-checking the LCA and the H-1B petition. The LCA dates should correspond with the H-1B dates. So we know that the start date should be October 1st on the I-129 petition, but the end date has to be either sooner than the LCA end date or the same as the LCA end date. So it cannot go beyond the LCA end date. Okay, then the LCA will be invalid and you will end up with the H-1B coming back, or you getting an RFE to which you can't respond because the LCA has to be approved before filing the petition. You cannot get an RFE and then file a new LCA to correct any errors in the LCA. Okay, so very important. Tip number 9. Evidence of beneficiaries' educational background has to be submitted. This is the whole crux of what a specialty occupation is, what a H-1 is. A H-1B is basically for only a specialty occupation job can file for a H-1B. So specialty occupation is a job that requires a person who has a bachelor's degree in a particular field. So if the person doesn't have that bachelor's degree in that particular field, or you don't submit it, then you're sure to get an RFE. And in addition to that, they'll ask you 100 other questions. So make sure that's basic documentation that you submit. It's not optional. If your degrees are in any other language other than English, then obviously USCIS does not have translators, so you need to send a certified English translation, right? It has to be notarized, done by, and follow all the rules for how a translation should be done. It should say that, the person who's translating the document is well versed in English as well as that other language, and the translation has to have a ditto copy of everything that's written on the original degree, and then it has to be certified by a notary public saying that, this signature is authentic. So that's how a translation has to be done. You could use professional translation service, or you could use someone who knows both languages, as long as the translation is done in the way that it needs to be done. So that's the evidence of beneficiary's educational background. And finally, number 10, if you have any dependents, please don't forget to file the dependent petition along with the spouse's I-129 petition. Because if the dependent is not filed along with the I-129, then the dependent might go out of status. For example, if a person is on an F1 and they have dependents on F2, if you only file for the F1 and you don't file an I-539 dependent petition to get the F2 dependent converted to a H4, then the F2 falls out of status, because the primary applicant, that's the spouse, will change status from an F1 to a H1, and so the dependent can no longer remain on an F2 and will automatically fall out of status, and at that point there's nothing you can do once they've fallen out of status. So make sure you don't forget to apply for, if you're an individual, don't forget your spouse. If you're a company, ask your employee if they have any dependents. Sometimes they don't know that they have to apply, so you have to ask that question. When you're filing for dependents, of course, there's a separate fee. Make sure you put in a separate check. As I said, all separate checks, and a separate check for the I-539 as well. Also, if there is a spouse and children, then you don't have to file a separate I-539 for each person. Instead, you will file an I-539 for the main applicant, and you'll file an I-539A for the children. And the fee is just one fee. You don't have to file separate fees for each person. Also, USCIS has told us recently through a court case that was won, that they have agreed to bundle the I-539s along with the I-129. So they are agreeing to approve the H-4 along with the H-1B. This is what they used to do before, but what happened then is during the Trump's administration, they started requiring biometrics for H-4 applications. So then obviously that it was taking longer to get the biometrics processed. So USCIS could no longer approve the H-4s along with the H-1s. So they stopped doing that, and the H-4s became severely backlogged. And in addition to the H-4s, the H-4 EADs as well. So both H-4 and H-4 EAD was now taking about 10 to 12 months to get approved. And this was really affecting the ability of the spouses to work. They would often lose their jobs because no employer will wait for 1 year, and wait for them to reapply or rejoin. So the good news then was that the biometrics requirement was stopped for H-4s. And so USCIS agreed to again bundle the applications together. So, for example, if you file premium processing, a H-1B petition, they will approve the H-1, the H-4, and the H-4 EAD at the same time, provided you file all applications at the same time. If you file it separately, again, there is a long wait. So my recommendation is make sure you file all the applications together, not just in a H-1B cap case, but in a H-1B extension case, even if the H-4 is not expiring, but maybe will expire shortly, like in 6 months or a year, it might make sense to actually file all of them together. With that, I think I covered all 10.
Yes.
We can just go to the questions now.
Yes. So, Ms. Prashanthi Reddy, my first question was, so whatever registrations, whatever the registration notice for the selected cases of the fiscal year 2024 are they indicated based on a regular or an advanced degree cap?
So the selection notices will say whether they are regular or advanced degree. So they definitely have that information on them. It'll say master's cap if it's master's cap. So if you file under master's cap and if they've selected it, then it'll definitely be master's cap.
Okay. Then how about what will happen if the required US degree is not awarded by the time of the filing?
Right. So when you're filing the H-1B registration, you can file the registration even though the person doesn't yet have a master's degree. So it's possible that they may not have it as yet, but maybe they will get the master's degree. They will complete it by April or by May, before June, as long as they complete it before June, because we have 90 days to file. So as long as they complete the master's degree before the date of filing, you're fine. So if they don't have a master's degree as of the date you file the H-1B petition, not the registration, that doesn't matter whether they have the degree or not during the registration. But by the time they file the H-1B petition, they should have either completed all the requirements towards a master's degree. And when I say that, I mean that maybe they didn't get the degree copy, in which case then they can get a letter from the registrar confirming that, the beneficiary met all the requirements. Or they can get the final transcript from the beneficiary, which shows that they have completed all the courses. Oftentimes, they don't get the degree because sometimes the convocation is delayed, or maybe they haven't paid the fee. There could be any number of issues. But make sure you're getting a letter from the registrar's office and not from some employee of the university, because there could be fraud involved there. If someone is just giving a letter, a professor is giving a letter that he's completed all the coursework, and if he hasn't actually completed the coursework, first of all, USCIS will not accept that letter. Secondly, there is a potential for fraud, so you don't want to be submitting a petition that could potentially, have fraud implications. So you have to make sure you get the letter from the right authorities. So to answer your question, you have to have the master's degree before the H-1B is filed. And it's not just a master's degree. The master's degree has to be from an accredited organization. It has to be accredited by certain accreditation agencies, which USCIS has recognized. And also it has to be an institution of higher education, and it should be a not-for-profit, or it should be public organization. So either non-profit or public organization. It cannot be a private organization. So there's all these requirements for the master's cap, which a lot of people don't realize.
Okay, great. So, Ms. Reddy, are you saying that can one apply for multiple similar H-1B petitions? So I'm talking about can the same employer apply for the same identical nationals multiple times?
So no, USCIS will deny or revoke those multiple petitions filed. First of all, the registrations itself won't get approved. They'll just deny the registrations. Even if they do and they find out later, and even if the H1 gets approved by some mistake, they will send a notice of intent to deny an approved H1. So, be careful when you've already submitted the registration. So hopefully you have not submitted any registrations that are duplicate. But remember, if you have two companies, say you're the owner and you have two companies with two separate federal ID numbers, as long as the job is different for the same person, you can file that person through both your companies. But the job has to be a separate job. Say if one person is going to be working at, Tata's, then the other person, the job should be at Microsoft. You can't have two applications for the same job and you're just filing them through your two different entities. Then that's not allowed by law, because then they will say that you have colluded in the H-1B registration preamble itself, there is, and in the attestation that before you file the registration, there's an attestation that you make where you say that you're not filing through two separate entities, related entities. You're not filing for the purposes only of increasing the chances of the beneficiary to get the H1. So two companies cannot collude together and decide to, file petitions for each other's employees, for example. So that's not allowed. But if it's a separate job offer, then it's allowed.
Yes. Ms. Reddy, are you saying that, so when must one apply for a CAP subject H-1B petitions? When can they file for it?
So they have to file within the 90-day window. So the registration notice will actually give you very clearly the period within which you have to file. But even without that, we know that you can file within the 90-day window. So for this particular pick or this particular lottery, we have until June 30th to file. So that's when we have to make sure we file. Say if a delivery, say you file it in the last week and USCIS can't confirm delivery or they've lost the package, then you can file another application as long as that other application is within the 90 days. And you have to explain when you're filing the second application why you filed the second one, that you could not get a confirmation of delivery for the first application. So that happens sometimes for people who like to do things in the last moment. So make sure that you're watching the FedEx delivery system and make sure your application is received on time. They don't care when you file, it has to be received on time.
Yes. Okay. Thank you so much, Ms. Prashanthi, for joining onto our show. We had an amazing, show. We covered so many different topics. I'm sure the viewers have enjoyed it. Thank you again for tuning. Thank you to the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.